The Supreme Court has made it clear in cases M versus Ryan, 1997, that the common law must develop in accordance with charter values. A trespass in common law equals an infringement or denial of a fundamental right or freedom listed in the Constitution Act or the covenant themselves. So this court judgment is showing us very clearly by the terminology that's being used. It stated that common law must develop in accordance with charter values. That's imperative. Not it can develop. Not some parts of it will develop. But it must develop in accordance with charter value. So if you try to use any other operation of law to claim common law, well, you're outside the scope of the jurisdiction of the courts. And you're outside of the rulings of the judiciary of Canada. And you're bringing a straw man argument before the court. A trespass in common law now equals an infringement of the charter, an infringement or denial of your fundamental right. What is common law? Common law often refers to laws that are based on the customs and principles of society. Now notice it used the word often, right? It didn't say always, but often. And it refers to laws that are based on customs and principles of society. So the governing factor for common law is to associate it with principles of society and customs of society, recognitions of rights that operate within the society. And these customs and principles of societies, which are used in court case decisions in situations not covered by civil law status. So common law stands apart from civil law and civil law status and civil law recognition. So common law is based on the principles of society, not covered by civil law. And it sets precedents for court cases or operations of rights. So principles of society set the precedent when calling on common law rights, common law operation of law. The ICCPR preamble, considering that in accordance with the principles proclaimed, well, there it is, right? Principles of society. And they're about to proclaim some principles to the societies. In the Charter of the United Nations, recognition. So principles that are recognized, recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. So the ICCPR just told us, right, that there are principles in operation in our society. And one of the principles that are in operation in our societies is the recognition of inalienable rights of all men and women. Inalienable right, a right that cannot be transferred or surrendered. A natural right, such as the right to own property. So legal definition of inalienable right is a natural right. Natural law, a physical law of nature, a philosophical system of legal and moral principles, purportedly deriving from a universalized conception of human nature or divine justice, rather than from legislative or judicial action. So natural law is independent from statutory law. It's independent from domestic laws that are created by the government through legislation. And a natural right is a right that is conceived as part of natural law and that is therefore thought to exist independently of rights created by the government or society, such as the right to life liberty, and property. An absolute right is a right that belongs to every human being, to every man or woman. So the ICCPR stated that it recognizes the principle of inalienable rights. And an inalienable right is a natural right that cannot be transferred or surrendered. It's a right that every human being, every man or woman possesses, and it's not given to them by the government. These rights exist independently of anything that the government can create or anything that the government can do. These inalienable rights belong to every man or woman, and they are recognized in international law under the international order. And these rights can never be limited or abridged. They are non-derogable by nature. No derogation can ever be applied to an inalienable right. And this is a principle of our society because the international order demands it. And Canada, as a signatory, is under the obligation to respect this principle of fundamental justice, to respect the rule of law that is in operation. In legal terms, peremptory means something that is final and cannot be changed or challenged. Well, that's our inalienable rights. They belong to every single man or woman. They are not given to us by the government, and no limitation or abridgment can be placed upon these rights. Therefore, they are peremptory in law. The term peremptory is often used in legal context to describe something that is final and absolute. When a decision or an order is described as peremptory, it means that it must be followed without question or the need for further explanation. That's the operation of your fundamental right. That's the operation of your absolute right. That's the operation of your peremptory right. It is final. They belong to men and women, and they cannot be limited or abridged. And there is a legal obligation upon all state parties who signed onto the ICCPR to respect these inalienable rights. Overall, the term peremptory signifies a strong, unyielding directive in legal context. The essence of peremptory is about finality and the expectation of compliance. Well, there's the legal obligation. The legal obligation upon domestic governments to respect inalienable rights. They are final. There's no arguing this point. They are peremptory, and they produce an obligation against all acting agents of the government of Canada. Period. The Vienna Convention on the Law of Treaties, Article 26. Every treaty in force is binding upon the state parties to it and must be performed by them in good faith. Good faith. You cannot deny inalienable rights. You cannot place a limitation and abridgment upon an absolute right, upon a peremptory norm. Because if you do so, you are acting in bad faith, not good faith. Article 27. A party may not invoke the provisions of its internal law, its domestic law, its statutory law, its civil law as justification for its failure to perform a treaty. Our fundamental rights, our absolute natural rights, our inalienable rights, they are peremptory in nature, and they cause and they produce an automatic obligation upon Canada and upon the government of Canada to respect and ensure those rights, not to limit them, not to abridge them, not to steal them, not to deny them. This is a legal obligation upon Canada, and Canada may not invoke its own domestic law in order to not perform their duty, there's no escape. There's no way out. The obligation is legal. The Vienna Convention on Treaties, the definition of the word party. Party means a state, which includes Canada, which has consented to be bound by the treaty, and for which the treaty is in force. And Article 27 says, a party, meaning Canada, may not invoke the provisions of its internal law as justification for its failure to perform a treaty. 52 times in the Vienna Convention is the word party used. 52 times to refer to the state party Canada or any other state party that has ratified their obligation under the ICCPR. Now, Article 26, every treaty in force is binding upon the parties. Well, now they pluralized it. Now they changed the word. Therefore, they changed the definition. And why this transpired here under Article 26, why they changed the definition of the word parties, is a video for another day. But I just wanted you to be aware that in Article 26, it says every treaty in force is binding upon the parties. Well, let me explain something to you. And let me share something to you. You know, when you're paying income tax to the state party, well, you're in a treaty with them. You're in a binding treaty with them under the income tax enactment. And that's why the definition of the word party has been changed here. Vienna Convention on the Law of Treaties, Article 52. A treaty is void if its conclusions has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations. So the state party Canada uses threats against you and says that if you don't pay an income tax, we're going to seize your paycheck. We're going to seize your property. We're going to put fines against you. We threaten you. You have to perform this treaty. You're under obligation to do what we tell you to do. And we threaten you to make sure you do it. Well, guess what? Their actions are illegal. And they are against the covenant. And they are against the International Bill on Human Rights. And they are not respecting peremptory norms. They are not respecting your inalienable rights, your absolute right, your natural right. They are forcing you to perform a treaty under threat. They are forcing you to perform an agreement under threat. Article 53. A treaty is void if at the time of its conclusion it conflicts with a peremptory norm of general international law. For the purpose of this present covenant, a peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted. Responsibility of states for internally wrongful acts. Article 40. This chapter applies to the international responsibility which is entailed by a serious breach by a state of an obligation arising under a peremptory norm of general international law. A breach of such obligation is serious if it involves a gross or systemic failure by the responsible state to fulfill the obligation. States shall cooperate to bring an end through lawful means of any serious breach within the meaning of Article 40. There's a legal obligation, a legal accountability upon Canada as a state party member to bring an end through the serious breach that they are performing. This is a United Nations report from the Commission dealing with peremptory norms and the operation of law that surrounds the norms that surrounds our inalienable rights. Now let's take a closer look at what the UN report stated and brought forth. To identify a norm as one of jus cogent, it is necessary to show that this norm in question meets two criteria. It must be a norm of general international law. Okay, that fits, right? ICCPR, Article 16. It's a norm of general international law. It must be accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted. All right? So when Canada signed on as a state party member and ratified their obligation to the ICCPR, they were accepting the operation of law brought forth under Article 16. Article 16 of the ICCPR reads as follows: everyone, the man or the woman, shall have the right to recognition everywhere it states, as a person before the law. Now, there's no limitation that can be placed upon that right. That's the whole verse right there. There's nothing else written in this verse of law, in this principle of justice. That's it, what you see. Compared to Article 21, the right of peaceful assembly shall be recognized. No restrictions may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society in the interest of national security or public safety or public order or the protection of public health or morals or of the protection of the rights and freedoms of others. Article 22. Everyone shall have the right to freedom of association with others, including the right to form and join trade unions for the protection of his interests. No restrictions may be placed on the exercise of this right other than those which are prescribed by law and which are necessary in a democratic society in the interest of national security or public safety, public order, the protection of public health or morals, or the protection of rights and freedoms of others. So we're looking at three different rights expressed in the ICCPR, and two of them are subjected to derogation. Two of them are not non-derogable. Two of them can be limited and abridged in certain conditions, and one cannot. One of these things are not like the other. Can you see which one it is? Article 16 is a right to which no derogation can be applied. Why? Well, because it's an absolute right. It's a natural right. It's an inalienable right. It belongs to every man or woman, not given to us by the government, but must be respected by the government. It is a peremptory norm of international law. That is why, in the covenant itself, there is no limitation. There is no abridgment that is provided for by the law to restrict this right, to remove this right. Article 4 of the ICCPR, in time of public emergency, which threatens the life of the nation and the existence of which is officially proclaimed, the state parties to the present covenant may take measures derogating from their obligations under the present covenant to the extent strictly required by the exigence of the situation, provided that such measures are not inconsistent with their other obligations under international law. And then it says in subsection 2, no derogation, no limitation, no abridgment from Articles 6, 7, and 8, Articles 11, 15, and 16 may be made under this provision. Well, here's a protection mechanism for Article 16. And it clearly states that no derogation can be made from Article 16. No limitation can be applied to it. So not only is Article 16 protected in and of itself, because when we look to Article 16, there is no limitation that can be placed upon it directly. But even during a time of public emergency, the principles of fundamental justice say you still cannot touch this right. And why's that? Why can't you touch it, State Party Canada? Well, because it's not yours to play around with. Because it's a natural right. Because it's an absolute right. Because it's an inalienable right, and you didn't give it to us. But you're under international obligation to respect it, and not to limit it, and not to touch it. Never, ever, ever. To identify a norm as one of peremptory status, it is necessary to show that the norm in question meets two criteria. It must be a norm of general international law. It must be accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted. Well, we just saw, right, in the ICCPR itself, in Article 4.2 and Article 16, that this is a right where no derogation can be applied. And Canada signed upon it and ratified its obligation. So therefore, it accepted its duty. And it's a peremptory norm. And it produces an automatic legal duty against Canada not to breach it. But guess what? Guess what? They're breaching it every day. They're breaching it through domestic law. They're breaching it through statutory law. And because most people don't understand this operation of law, and because most people don't understand their absolute inalienable rights and how law protects them, Canada is getting away with it. And what's Article 16 saying to you and saying to me? What provision is it bringing forth? What is it protecting? What's the operation of law? What's the principle of justice? What's the rule of law attached to Article 16? Well, it's what everyone's looking for. It's what all these gurus are out there trying to tell you that they found a way to it. But they didn't. This is it here. The expression of it here. Everyone looking for their common law rights. Everyone looking for their freedom from the government. Filing UCC. Filing trust laws. Filing documents about God. Telling you and teaching you, well, everything's a contract. It's an offer and acceptance. And if you just don't accept, then you're free from the government. Bunch of garbage. Courts have already declared so. Courts have said Canada will unilaterally apply their laws against you, only subject to the Charter. Which means what? Well, only subject to common law. Which means what? Well, only subjected to peremptory norms under the international order. That's the way out. That's the door. No other door. Can't make up your own door. Understandest thou not that what you're reading here in Article 16 is the operation of your absolute right, your inalienable right to what? To be recognized as a man or woman before the law, without any additional obligations or impositions placed upon you. And that's your right to stand before the law in that capacity. But some will tell you, well, you're not a person. You can't be a person. A person in the law is made up. A person in the law is a mask. A person in the law it's a created creature. Oh, don't be a person. Law recognizes you as a natural person. Your natural personhood, but only when you're standing as a man or woman. And under that recognition, under that principle of society, under that peremptory norm, that obligation, they recognize you without any additional obligations to the government. Under your full legal capacity, owing no duty to the government at all. And these guys are out there picking your pocket and confusing you and telling you, well, no, it's a person. Don't take recognition. Well, it's a person. Because they understand not the rule of law, and they understand not the principles of justice, and they're picking your pocket with law, and they're picking your pocket of money. Thomson Newspaper Limited versus Canada. While individuals, as a rule, have full legal capacity by operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. So, when you're standing under your full legal capacity, you are operating under your natural personhood. You are operating as a natural person before the law. You're not operating as an artificial person, as a driver, as a hunter, as a fisherman, as a student, as a patient, as a consumer, as a homeowner. That's not the recognition of law you're standing under. That's the type of person that you don't want to stand under. But when you stand under your full legal capacity, you're standing before the law. The law recognizes you. It looks at you and sees you as what they term natural person, natural personhood. And it sees you with no obligations, no impositions, no duties to statutory law. The individual may stand upon his constitutional rights. What are you standing on? What does it say you're standing on? Well, you're standing on your constitutional rights. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land long antecedent, long before the organization of the state, and can be only taken from him by due process of law. All right, Canada. All right, state party. Do you have a due process of law to place a limitation and abridgment upon Article 16? No, you don't, right? Because it's a peremptory norm. And it commands automatic legal obligation and legal duty not to place a limitation, not to place an abridgment, but to respect it and to honor it. Why? Because you didn't give us these rights. You didn't create this right for me. It's mine because I'm a man. And you are under obligation to respect it. And there's no due process of law that you can use to place a limitation or abridgment upon it. Why? Well, because the international order has already declared so. And you signed upon it. And you ratified it. And you took up the obligation. Therefore, you are guilty as charged and accountable before the law. Anytime they force you out of recognition as a natural person, or anytime they try to put an imposition or a duty, a statutory duty upon your natural person, because that's the two ways they do it, right? They think they're slick, right? They either directly change your status before the law, and they recognize you as a statutory creature, as an artificial person, such as the driver, such as the hunter, such as the fisherman. They're changing your status in the law, or they keep your natural status before them. But then their statutory power tries to apply a duty against your natural personhood, tries to apply an imposition through statutory law and say, oh, you owe us this obligation. Oh, no, I don't. That's an illegal operation of law. When Article 16 says, everyone shall have the right to recognition everywhere as a person before the law, when you're standing as a man or woman under Article 16, you do not have any duties attached to you. Created through a democratic society, created through statutory law. And Thomson Newspaper just told you that. Says you owe no duty to the state. Well, then how come they're coming at me and saying I owe them a duty under the Income Tax Act? Or how come they're coming at me and telling me that I owe them a duty under such and such enactment? Well, because they're breaching peremptory norms. They're breaching their obligation to absolute rights, to inalienable rights. And they're banking on the fact that you don't know what they're doing. That's why they're doing it. Because they're criminal. And they're expecting not to be caught.